All right. Let me call them. In the matter of People versus Gene on 251361, appearances for the record.
Order, Your Honor, Adam Kanishevsky on behalf of Mr. Chu.
And are there any additions, subtractions, or deletions?
Mr. Judge needs to be changed to you. My copy says Judge Meter.
No.
Out of that.
And then is there anything else by way of elocution?
Yeah, I'll just point out he's, excuse me, he's 28 years old. He has no prior criminal history. This case was going on. It's going to got a contentious divorce about a fourth floor that is now been finalized. He's indicating to me he has like just over 40% custody of a minor child. This case stems from a house visit. I believe that was ordered by Judge Dinkin.
No, yeah, that's light up.
Oh, sorry. To inspect the house. Obviously tensions were high. It was a contentious divorce. Mr. Gene acted in a way that he shouldn't have. He fully recognizes that. But, you know, the victim wasn't injured. He wasn't struck in any way, shape, or form. But he did put his hands on her, which is, you know, his fault. He understands that. That being said, he just wants to get this behind him. He can pay his fines and costs today. I'd ask the court to consider under all the circumstances, consider maybe a shorter period of a deferred sentence. That was part of the plea deal, so I do ask the court to put him on the deferred sentence. As far as contact with Taylor Gene, I believe they've been using and they're using through the family court. Just ask that number 9 if I should still allow them to contact for child welfare matters.
I understand that Miss Jean is also here. Slaughter,
Yeah, I'm sorry.
Miss Jean is here as well.
Yes. Energy.
And for elocution.
Just slide over. But see, I think it's it.
Good afternoon.
Hi,
You want to state your name for the record?
my name is Taylor Jean.
And what do you want me to know?
Bear with me. I see the pictures.
Okay, be careful with the mic, please. That's okay.
My name is Taylor Jean and I am the victim in this case. I am choosing to stand today and make a statement because I read something a few weeks ago that really stuck with me. It read, "They don't have to hit you, choke you, or slam your head into a wall in order for it to be domestic violence. They can also degrade you, humiliate you, blame you, scream at you, lie to you, destroy your property, withhold finances, manipulate you, or even just try to control you, and it is still domestic violence. While my case physically involves shoving and forcibly moving my body while grabbing my phone from my grasp, it also includes the intangible things I just listed. Every single one of them. And let me tell you, the bruise on my arm after the incident with Alex on March 23rd, 2025 is nothing compared to the bruise on my emotional well-being that formed after years of torment with this man. I have been in therapy for a year and a half now, working through what we've been considering calling complex post-traumatic stress disorder. Oddly enough, I will never forget the relief that I felt that day that I sat in my car in his driveway after the altercation and realized my ex-husband had finally put his hands on me. It validated everything. Everything I had ever gone through with him. It validated me crying to my parents, saying if he would just hit me, I would leave. Can you imagine the pain in my father's eyes when he heard his daughter break and speak those words? Everything Alex had ever put me through had finally come to a head, and I could hold him accountable for the trauma I have endured. It was tangible, on video, it formed a bruise. There was no denying what had happened this time. There was just the reality of it. Finally, it was real. It was that real, that bad. It's pretty wild to say I felt a relief when he put his hands on me, but I think that only true victims of this kind of abuse from their ex-husband can ever understand. I spent years being lied to, manipulated, threatened, abused, and completely neglected by this man. It was not until I gave birth to our daughter that I realized I couldn't let her be raised in a home that felt like a war zone. It is because of her that I filed for divorce when she was 6 months old, and I did everything in my power to keep her safe. I thank God every day that she's been young enough during this process that she will not remember it when she gets older. But Judge, she's 2 now. I can no longer say that's the case, and Alex's behavior and mental health is at an all-time low. I'm more worried for my daughter's sake than any of my own that she has to be raised by a man that would do this to her mother and not have any remorse or care to be better. I'm so thankful that it was me he chose to victimize that day and my daughter only witnessed from the other room. I'm not convinced I'll be the only victim though. I came out on the other side of this purely because of the woman that I am and always will be. The woman that my parents raised me to be, and the woman that my daughter will always be protected by. So many other women are not as resilient or capable as I. So many women fall short in their abilities, especially as a young single mother, and let their internal fire burn out. But I refuse to do this, as my daughter deserves better. The only reason I was in the position that day to be a victim was because I was protecting my daughter. I was gathering video evidence of marijuana within reach of my daughter, which immediately broke a court order that was put in place not even a week prior. Alex decided it was a better idea to shove me through the doorway and grab my phone instead of follow a court order or stop using marijuana altogether. He had no regard for the court order protecting his daughter from him and his drug use. His decision to put his hands on me and prevent me from photographing the incriminating situation proves he knew what he was doing and acted on his own free will to protect himself from being caught. This is how he treats the mother of his daughter when he feels under pressure to hide his reality. Do you really think he will hold any regard to a case that only has to do with his ex-wife that he already hates and blames for everything? He chose drugs over our daughter's safety. He's going to continue to choose himself over anything short of a year's worth of intense help that he cannot hide from. He will scratch and claw his way through a 6-month probation sentence. It's not long enough and will be a waste of time. You will be back here in court with the next girl or my daughter as a victim if you do not act now. I beg you to give my daughter a fighting chance at having a father that got the help he needed. I ask you, if not jail time, thank you, to place the defendant on a minimum of 1 year of probation for accountability purposes. I would like him to receive a mental health evaluation because my daughter does spend time with this man unsupervised, despite having had open CPS cases, a history of suicidal attempts, and a period of time where my daughter was not allowed in his home at all. I want to ensure he's determined to be a safe and mentally sound parent for my daughter by a mutual third party. I would also like to see him participate in what I believe this court calls the color code drug screening. He has exposed my daughter to drugs and secondhand marijuana use. He's dependent on it to get through his day, whether he's parenting or not, and I want him to live a better life than that for my daughter's sake. I would like him to take domestic violence prevention classes so that the next woman in his life is safer than I was. I ask that the no contact order between he and I remain in effect for 1 year from today's date or the length of probation, whichever is longer. And I want him held accountable starting today. I ask you not to give him grace as he thrives on and abuses people's kindness and unfortunately his family's deep pockets. I ask you to remember that he already forfeited bond, failed to attend his own pre-sentencing interview with Ms. Slaughter, neglected to appreciate the fact that I agreed to a deferred sentence, and already got 2 adjournments. I have already scheduled 3 days off of work to attempt to attend this hearing, spent sleepless nights repeating this case over and over in my head. I've gone through lengths to heal myself from the trauma and prevent my daughter from realizing mom was hurting so badly. I ask that you please finally hold this man accountable for the trauma he's caused so he doesn't continue to hurt my family, the family of his new girlfriend, or my daughter next. Thank you for your time today and taking my thoughts and experience into consideration.
Thank you, Ms. Jean. Let me ask you though, with regard to the contact that required in order to raise your daughter, you utilize the app Flows, is that correct?
Yes.
And that has been working then?
We are also dealing with a judgment of divorce.
Your judgment was final back in November of last year, wasn't it?
It was December 11th,
December.
2024. He had until August 11th of this year to get debts refinanced out of my name, and he has not completed that. So we are unfortunately still having to deal with that. There's a court date being managed by my attorney in Lake County. We're still dealing with this
Let
judgment.
me ask, I've known Judge Clyde for a very long time. These things that you speak of, why has she, what has she done with regard to visitation? There is basically a 50-50 visitation.
She referred our case to front of the court to have a full reevaluation.
Is that back in May of this year? Or March?
May, sounds correct.
So she's aware of what you have indicated.
Yes,
So the video then that you took of that when you were in his house, she is aware of,
yes.
and what was her ruling with regard to that? If any,
Ruling in regards to,
how did she
Anything?
handle that, do you know?
she never saw the video. She was just aware of it. It was not part of the case as we were coming to deal with that case here. It was not really,
She took, Mr. Dean into custody on the day of that hearing, did she not?
yes.
And she did not do anything further as a result of your video?
No.
Did Miss McGrandy, provide that information to Judge Galida?
I,
And did Miss McGrandy ask for a hearing regarding that?
not regarding this case as it was being
Not
handled.
this case, the marijuana that you said, his house. I'm trying to get an understanding.
I know, I just, I wasn't, we ended up in court I think twice in the summer. And then it was referred to front of the court and that was it. Sorry, I don't, I answered you.
No, I appreciate that, helps me. Any other questions right here?
Do I have any other questions? This covered it.
No, I think we're covered. Thank you for your testimony. Anything else, Mr. Kanashevsky?
No.
So here is what I'm gonna do. I have, Mr. Jean, no prior record. I've had a chance to review not only the pre-sentence investigation, I've also reviewed all reports regarding the matter and had a chance, well, I did not talk to Judge Kalida, but I did go through and review the record with regard to the divorce case that Mr. and Ms. Jean had. I don't believe that this court is gonna be one that resolves whatever issues are between the two parties. The thing I can do is give the tools necessary, at least for Mr. Jean, to move forward. I would caution both parties that the best interest in this matter is his daughter. Sometimes that gets lost in the divorce case. That is more of a general statement than anything else. Caution is what I see of cases that come for me. The focus I'm going to take on this is that Mr. Jean be referred over to CST counseling for a program to address the issues that this court is aware as a result of this case. Whether that assessment is a batteries in transition of a 52-week program, I'll leave that up to Ms. Joseph, but that is, I'm not going to refer to PPS, it will be with Ms. Joseph. Now, with regard to monitoring, I believe that the 3 months for its sentence would give me that opportunity to monitor whether or not Mr. Jean is going through the program sufficiently and with the appropriate approach. While I will not monitor what is discussed between Mr. Jean and Ms. Joseph, I will monitor whether or not your participation is genuine. Should it not be, then I will violate, bring it back. I will know that within the first, actually the first month of your attendance. So with regard as amended with the 3 months. Everything else remained the same. As amended, I will take the CST counseling, referencing the comments that I just made. Now, with regard to number 8, it is my understanding that there is a diagnosis of Crohn's disease. If I had medical documentation from a qualified, bona fide doctor-patient relationship, then I will re-examine the use and how that is used. In addition, coordinating with Judge Kalida in that case. No contact, Miss Jean. Either in the place of employment, residence, or in person, third-party telephone writing. Yes, with the exception of the app close, that would be the only form of communication. The alternative is 92 days, I believe, bond. If not, then it's not covered, then time to pay 60 days. Both you and Mr. Jean are the best. Have any indication from Ms. Joseph? Then there will be a violation. Big one. In the matter of People versus Puga on file number 253876.
Just lost the thirty of Mr. Puga, who stands to my right.
Are there any additions, subtractions, or?
Well, yes, I did want to address the pre-sentence report.
Yes.
This matters. Because it became clear through discussions that I've had with my client and conversations he had had with the probation agent me later, that there was some confusion about what the nature of the plea was in the case, and that is.
Count 2 is not part.
That's
Count 2,
correct.
Yes.
Yes,
So
because I
that is-
confirmed that with the prosecutor.
That
this
would be
morning
stricken from
because of the
the
confusion.
report.
Okay, thank you.
Yeah.
So I would just ask those be struck then, and also the recommendations contained therein pursuant to the charge that is accurate.
I believe what I did there, though, was that wasn't he to.
Yes.
CST.
Yes, he did make the contact. The probation agent did in fact verify that the contact in fact had been made.
Okay.
I don't have anything further in this regard. I don't know whether my client wishes to speak to the issue.
Is there anything else? Rich?
No, we are.
So then with regard, I'm gonna amend count 1 inspection. What did Ms. Joseph say? Did you just enroll?
He had to kind of just set it up. Yes, that's what you did.
Okay. So what I'm gonna do then is amend count 1, do the 3 months. Supervised probation. 4 days credit. Given the cost you're gonna have with Ms. Joseph. Drop the fines down to $100, fines and costs, 75, 50, 30. Attend and complete. CST. And random and refrains. And as will be explained. And then alternative is 661. Again, I have not signed the domestic violence dismissal. I will not sign it until I have indication from Joseph that you are in the time to pay 60 days.
I shall verify.
Is there anything further?
No, you're on. Thank you.
All right.